It's a new month, new art. I thought you and Brittany were attending in person. Oh.
Hi. Well, you might have stuff at the bottom.
That's weird. Yeah, every time I slideshowed it, it came up as a full screen.
Yeah. On purpose. I didn't recognize you at first.
No idea.
There's no microphone in front of my face, huh?
But it's not. That's how I saw that. I think
It's awfully small, though.
you can't read
All
it.
right. Well, I don't need to be able to read it necessarily, but I'd like them to be able to read it.
Can you guys read that?
Is there words up there?
And you wonder why she's going on.
It does seem a little bit.
I'm trying to behave. I'm trying.
It's level 1. You need to get
Okay, you gotta cut this somewhere. Might as well
That's
use
better.
one,
Yeah.
All right, apparently it's all up to me. Well, welcome everybody to today's community business lecture series. Everybody being the 4 of you that are here. If you're here for business law, you're in the right place. If you're not here for business law,
Oh,
fix
I'm
that.
sorry. I'm sorry. Oh my gosh.
Technical difficulties, it's all right. All right, perfect. For those of you that don't know me, but I think everybody here does, I'm Greg Stein. I'm a local boy.
They won't know you though.
May not. Here's some things I did, places I've been. I currently work for Holmes, Weddell, and Barcott here in Kenai, and I specialize in business law, specifically business formation. I'm what they call a transactional attorney. I don't go to court if I can avoid it, and the only times I go is usually when somebody needs a favor. So don't call me when you're in jail. Yes, I am the son of George, everyone's favorite retired accountant. And yes, he did all those things for you or your daughter or who knows. That does make me Jane Stein's grandson, and Dan and Kathy Gensler, my aunt and uncle. I only put that in here because every client I sit down with, when I meet with them in my office, eventually puts together one of these connections. So now they're established and we can move on with our lives. I do have 3 sons, 14, 11, and not quite 1. And I am married to the world's cutest redhead, Shelby. So if you need insurance, please stop by State Farm when you get done here. I like to shoot guns. I am a huge D&D nerd, and my golf handicap's about a 15. For those of you that don't golf, I'm a pretty okay golfer. I'm not great. I'm not going to make the tour anytime soon, but I do all right. And somehow I became the president of the Kenai Chamber of Commerce in the fall of 2022 through a series of roundabout events. So here we are. So since I joined the board in 2019, I've been advocating for a series like this. I sort of always felt that we didn't do enough for our members in a direct way. This is the kind of thing I'm excited to see Sam put this all into effect, and I've been super happy with how it's turned out so far. That being said, I probably wouldn't have advocated so hard if I knew I was going to have to participate. So I regret everything, obviously. But I think it's a good thing. I think it's a good thing for our members. I think it's a good thing for the chamber in general. So I'm super happy with moving forward with it. Because I'm a lawyer, we have to go through the disclaimer before we get started. So make sure you can all read that. Everybody can read. We're good. Okay, take your time. I'll wait.
You represent 25% of the people in here.
That's awesome.
All right, now let's get to the heart of the matter. Lawyer jokes. Everybody always has some, so I usually just get them out of the way to begin with. That way I can control which lawyer jokes are said. What do you call 100 lawyers at the bottom of the ocean? Anybody?
I made the slideshow.
Nothing? It's a good start. What if 100, or what if 10 of them survive? It's a damn shame. Last one, what's the difference between an accountant and a lawyer? Accountants know they're boring. This one is very true. We lawyers, we love to think that we like to think we're interesting people, but today's sexy topic tells you otherwise. So today's key question, why are we even allowed to make companies? Anybody know the answer to that? Go ahead.
I made the slideshow.
I know. But the answer is, so you can safely fail, right? Companies allow us to put walls between our personal and our business assets. That's the whole idea. Now, somebody probably watching this is going to think to themselves, well, that's not correct. When I had a business, I had to make a personal guarantee on every loan I had. Okay, that's probably true. So the state wants you to be able to safely fail. The bankers hate you. I don't know what to tell you. If you're going to get a loan to start a business, there's going to be some requirements, and yeah, you're probably going to have to personally guarantee that loan. So while you can safely fail in the eyes of the state, it doesn't mean you can safely fail in the eyes of the bankers. That's a key difference to keep in mind, and people often forget that. So what we're trying to do is give you the opportunity here by the state to do something that doesn't put all of your personal assets at risk. The bank disagrees with that approach, and that's their prerogative. It's their money. They can do what they like. But this is the key concept behind what we're going to talk about today, because this is what we're trying to do whenever we set up a business entity. We want to be able to keep that wall up, and we want to be able to maintain that wall, because the moment that wall comes down, you are putting your personal assets at risk. And this guy does the running man and the chicken dance. I might be able to pull off the running man, but I'm not going to try the chicken dance. All right, so there are various types of business entities. I'm going to look at 4 real quick here, and then we're going to focus on corporations and LLCs as we move forward. The first is a sole proprietorship. This is a non-entity, if you will. Usually this is somebody who has a little craft they want to do, or some small business with extremely low liability. The chances of them being sued is going to be absolutely minimal. And so instead of going through the process of setting up a corporation or an LLC, all they're going to do is go get a business license from the state and start selling their goods or providing their service. I don't recommend a sole proprietorship for any business whatsoever. It is hands down the worst way to go into business, but that doesn't always mean that it's bad. There are some things, like the example I provided, where there's basically zero liability and you're not talking huge dollars. For something like that, okay, maybe just going to get the business license is fine. As an attorney, though, I cannot ever recommend this for anybody, because that would be foolish. It is foolish. It's dangerous to do. So we don't do sole proprietorships, but a lot of people do. A lot of people take the risk, and we don't like that. Instead, we look to these kinds of entities, including a partnership. I don't do a whole lot of partnerships in my business, mainly because a lot of people don't understand the relationship, and they're not very helpful in putting together the partnership agreement. Partnership agreement is going to control everything a partnership does in terms of who's putting in what money's coming out and when, who's got the votes, who's going to run the business, all that kind of stuff. Because of that, and because of the nature of partnerships generally, each partnership agreement to be properly done needs to be unique. You need to have both parties sit down with me and sort out exactly what the partnership agreement is going to say. Most people don't want to take the time to do that, and most people aren't sophisticated enough here to understand what they're putting in or taking out of such an agreement. So generally, I will shy away from these unless it's a partnership between already existing entities. So every so often, I'll have clients that'll come in, and we've got an LLC and a corporation already. They want to tackle some kind of joint venture. Okay, we could then set up a partnership that would usually be temporary in nature, a couple of years or something like that, whatever it would take to accomplish the goal. And in that case, we might use a partnership agreement instead. Obviously, there are certain tax ramifications that come with some of these things. We'll get to a little bit of that later. But that's the one time that I'm generally comfortable putting a partnership together. Otherwise, anything you can do in a partnership can be done in a corporation or LLC just as easily. And you get a little better court protection, I think, in terms of somebody breaking down that wall. So we shy away from the partnerships as well. Corporations. These are the ones everybody's familiar with. This is everything from a closely held corporation like my own family corporation, Valhaven Incorporated. We own a farm in Indiana. That's all the corporation owns. That's the asset. All the way up to your Walmarts, your Exxons, your Fortune 500 companies. All of those are corporations. They all essentially operate the same. They all essentially have the same kind of protection through the court system. The downside to corporations is that there's a certain set of formalities that have to be maintained in a corporation. There's a separation between your board of directors, there's a separation between your shareholders and your executives and officers. Sometimes, for a lot of businesses, especially for what I see here in my practice, it doesn't make a lot of sense to put together a corporation when there's one person involved or even two people involved. The corporate formalities can be somewhat unnecessary. So typically, that puts us leaning more toward a limited liability company. So it's a relatively new type of entity, has only been around since the late 1970s, but has enjoyed good viewing from the courts in the way it protects the assets. So they don't really distinguish it much from a corporation. So less effort in terms of formalities and same kind of protection. So of course, this is where I want to lean when people come into my office. If their business model fits an LLC, I'm going to take an LLC over a corporation every time. It's easier for them to handle. They don't have to wear as many hats when they're going through the process. And it's just easier for everybody to understand. This is an area of law where there are probably attorneys out there who will disagree with this assessment. They may not agree that LLCs have been protected to the same degree corporations have in the state of Alaska. I haven't seen anything in particular in the case law, and it's been a few years since I've gone through it. But I haven't seen anything that leads me to believe that that's correct. From what I can tell, an LLC has the same amount of protection that a corporation is going to give you. And it's just a lot easier to deal with. And yeah, anytime somebody comes in for a partnership, this is what I'm going to steer them toward instead. You want to be 50-50? Let's be 50-50 members in an LLC. We can do that. So we're going to focus on corporations and LLCs today because those are the two that we do most often. Those are the two that people tend to be familiar with. And of course, corporations being basically the oldest business entity. I guess one could argue that the East India Company was probably a corporation. I don't know when that was, the 1600s or something. So they've been around a long time. They've enjoyed a lot of protection from the courts, and people are used to the way that they're supposed to work. Most people don't really need an in-depth explanation of how a corporation works. They sort of inherently understand that from just general life experience. That being said, I did go through and sort of explain the different groups that are involved in the corporation. Your shareholders or owners, typically denoted by shares of stock. So those are physical stock certificates, typically. People used to keep those individually in the stock drawer. People would find them, and after somebody passed, and they'd have the actual stock certificate for the oil company or whatever they had. These days, even in a close corporation, it's more common to keep the stock certificates with the corporate book. So they're filled out anytime there's a transfer, but we don't actually give them to the shareholders to hold on to. Whether that's, I think that's really more just an issue of convenience. It becomes commonplace when you hand out stock certificates that people lose them. So far easier to just keep them with the book and track them on the corporate ledger and then keep everything together. Corporations can have any number of shares. Ideally, it's going to be some number that allows you to have additional shares held in check in case you want to issue those down the road. Typically, we see anywhere between 100 to 100,000 shares. Most of the corporations I put together have either 1,000 or 10,000, depending on the type of company and who's involved. In a corporation, the board of directors, they're the kings. So the directors make all the major business decisions for the company. People get that confused sometimes in thinking that the shareholders are the owners, but it's the board of directors that makes all the decisions. And it's the board of directors that has to issue any resolutions to do business with a third party. Board of directors oftentimes in the company may only be one or two people. It may just be one person. Sometimes we set up a corporation that only has one person, one officer, one shareholder, one director. That's fine. Again, typically I would push that person toward an LLC instead of doing it that way, because now look at all the hats they have to wear as a corporate owner. Oh, am I doing this action as a director? Am I doing this as a shareholder? Or am I doing this as an officer? It can be easily confused. Does it matter a lot? Not a lot, but there are times when it does. There are times when it has to be done right. So the final group are the executives and officers. Those are the white collar positions everybody recognizes from the movies, and everything from your president, vice president, treasurer, and secretary to CEOs, CFOs, and vice presidents. I worked for a company that had, I don't know, everybody was a vice president. They gave them an officer position within the company. It made some things easier because now they were an officer and they could be authorized by the company to handle certain transactions. So even though they were like the head of HR, technically she was the vice president of human resources. So it's not uncommon in your larger companies to see all those things. It's far less common in the kinds of corporations that I put together. Typically, you'll have maybe a president and somebody who serves as treasurer and secretary. And then you may have another position in there, somebody who fills in as either the vice president, or we call them a CEO or a CFO or something like that. And of course, officers do serve at the pleasure of the board of directors. So when it comes to terminating an officer, that has to be done through the board. And so these are the formalities required of a corporation. Typically, what we're talking about is an annual meeting. A corporation has to have an annual meeting of the shareholders, typically followed by an annual meeting of the board of directors. In a small corporation, in a close corporation, what will happen at the shareholders meeting is the shareholders will discuss the directions and goals of the corporation and either use that time to draft their own resolutions that go to the board of directors, instructing them on what they'd like to see, or maybe just being put into the minutes so that there's a record of what the shareholders were interested in. Once the shareholder meeting has taken place, or when the shareholder meeting is taking place, the other thing that they have to do on an annual basis is vote for the board of directors. So each director is elected by the shareholders. Typically, that's typically thing that really happens at a shareholder meeting. Sometimes other stuff can go on, but the board members basically rep the problem with the direction the company is taking. You basically have to use your shareholder power to vote somebody in who's going to do more of what you want than the board that's there currently. Oh yeah, I did put that note in about Robert's Rules of Order. People are always harping on Robert's Rules of Order. Well, do you guys use Robert's Rules of Order in your corporate meetings? No, people do, and you can, and yes, it provides a set of guidelines that people can understand and follow. Is it necessary in most board meetings? No, it's really not, because usually it's 2 or 3 people sitting around a table. But I constantly have clients that come in and like, well, don't you have to use Robert's Rules of Order? I'm like, no, there's no requirement anywhere for that. And so here we get to dealing with third parties. So we're talking about other companies, lenders, vendors, possibly anything like that. Any corporate action that's going to be anybody that needs something that says the corporation agrees to do X has to come from the board of directors. So you've got to have a resolution from the board. Resolutions typically will come from a meeting, usually a special meeting, because the annual meeting, you already have stuff to discuss. So usually this is something where you're going to call a special meeting of the board of directors. You're going to draft a resolution. Board of directors is going to vote on it and hopefully approve it. And that's for almost anything where you need corporate authority. Sometimes say in an annual meeting or a special meeting, the board of directors may grant lasting power to an officer. So they may draft a resolution that says the board of directors hereby empowers the president to handle all financial transactions on behalf of the corporation effective this day through whenever. That's sort of one way to work around that requirement of constantly having to get the board of directors together. In a larger organization, it can be very difficult to pin everybody down for a special meeting. We know that here at the chamber. We've had that issue a couple of times. And so that's one way to do it. The other is that you can have everybody consent, typically in writing, so via email is usually fine. But something in writing where every board member has gotten the chance to vote on the issue and been apprised of proper notice and all those kinds of things. All right, profits and losses of corporation are borne by the shareholders. So this is something that in a corporation you cannot change. If you own 100 shares of a corporation with 1,000 issued shares, you're entitled to 10% of the profits or losses. That's it. If you want more, you've got to buy more shares. So we can't adjust that in the bylaws or anything like that. 100 shares is 10% of the company, end of story. There's less flexibility in a corporation for that than there is in an LLC. And I'll get to that in just a minute. But that's key to remember because that's probably the key difference between a corporation and an LLC for the most part in terms of the profits and losses. You're pinned in by the shares on a corporation. You're not necessarily pinned in by the member interest on an LLC. Different classes of stock. Every so often I have somebody who comes into the office and they'll sit down across from me at my table. They'll say, well, I think I need to set up a corporation and I think I need different classes of stock. See, we want regular voting stock, Class A stock, but we also need Class B stock that's a non-voting stock. And I'll just sort of glare at them across the table and wait until they're finished. And I explain to them that if you really need those things, this is the wrong place to be doing that. Alaska courts, Alaska judges, they're not familiar with these kinds of things. They see DUI cases. They see sexual assault cases. They see divorces. Maybe they see a probate case once in a while. They see a guardianship. Alaska judges do not understand business law. They do not have any understanding of things like trusts or how they work or how they're supposed to work. And if you're going to have a corporation that has multiple classes of stock and something happens down the road, I would not want to put you in front of an Alaska judge. Now, that may, I don't know if I'm supposed to be saying things like this, but that's my personal feeling from what I've seen. They don't see this kind of stuff. They don't know this kind of stuff. They may have only taken one business associations class in law school and completely forgotten it. So if you are in a situation where you need multiple classes of stock, it can be done, but you might as well go the Delaware route. Make a company out of Delaware and do it that way, because if anything goes wrong, the Delaware courts, well, they're very, very familiar with this kind of stuff. They understand it inherently. So there's a huge advantage to that. There is one time I made multiple classes of stock. So there was a company that was owned by a husband and wife. Wife was basically in control of the company, but it was a 50-50 split in terms of ownership. And the divorce was contentious, and husband started going into the business and doing things he never did before. Started messing with employees, started trying to mess around with some of the assets and things. And because the divorce was already pending in the courts, if I remember correctly, went to the judge and said, look, we can't have this because the corporation was literally their livelihood. So we can't let this thing get run down because of the actions of somebody who thinks they're hurting their ex. And so we went to the court and we said, well, here's what we can do. We can change the singular stock that we have, and we can make two classes of stock, one that has voting rights and one that doesn't. And we'll issue equal amounts of stock to each person, but the wife will have the voting stock, the husband will have the non-voting stock. Thus, financially, they're entitled to the same 50-50 profits or losses. that was a great solution. It's the one time for a corporation. It was like, that's great. The problem with that was I'd filled out all the paperwork, found the statutes under which I could file it, and I sent it off to the state. And about 2 weeks later, I got everything I sent in the mail back. So, well, that's kind of weird. And I opened it up, and there's a piece of paper on front that's written on official letterhead that says, "We don't understand what you're trying to do here. We do not appear to be able to accommodate this request." I said, okay, that's interesting. So I looked up the statute that says you can do this. And I called up the Department of Commerce and talked to somebody there. And she was like, well, nobody here has ever seen anything like that done. I said, well, the statute says you can accept this filing. So, okay, let me talk to my supervisor. Eventually, they accepted the filing. I had to repackage everything up, mail it back up to them, and they accepted it. The reason I include that story is to go along with what I just told you about judges. Alaska, in many ways, is still a little frontier podunk state from a legal standpoint. The Department of Commerce that we'll talk about a little later here, at one point only had 2 employees, neither one of which had been there very long that I'm aware of. So it didn't surprise me necessarily when it was sent back. The kind of stuff you're going to run into when you start to do tricky stuff here in Alaska. So if you've got something tricky you need to do with your stock for some reason because you've got angel investors or whatever, I don't recommend doing it here in Alaska. So it is what it is. All right, so how do we create a company? In most states, we do this through the Secretary of State's office. We do not have a Secretary of State. We are one of 3 states, Utah, and I can't remember the other one. So instead, we have the Department of Commerce, Community and Economic Development, Division of Corporations, Business and Professional Licensing. That's where there's 2 employees. So the way to create a corporation with the state is to file your articles of incorporation. This document basically will ask you, what is the company going to do? How long is the company going to be in existence? And please select a North American industry classification code for your business, and who will be your registered agent. Usually my answers to those are, what business are you doing? Any lawful purpose. And the state allows you to fill in any lawful purpose on that. I never specify on the articles of incorporation what I'm doing with the business. How long will the company last? The answer there is always perpetual. So whenever the company is dissolved by its owners, it's dissolved by its owners until such time it has no end date. The NAICS codes are always a bit of a challenge. I usually prefer when an accountant tells me what kind of company it is and the classification code for it. That doesn't always happen. Sometimes I have to go through with the client and kind of decide what the best code is. In Alaska, some of the codes are keyed to a professional license. So you cannot choose the code unless you're going to tie your professional license to the company. This used to be a huge pain. Again, I had 2 people working this, but the Division of Professional Licensing, so Division of Corporation Business. So the professional licensing people were different than the corporations and business people, and they only met every couple of weeks. So in the past, you used to have to submit the paperwork and hope you got it in time for the next meeting so that you could finalize your company within a certain amount of time. Sometimes that didn't happen, and I don't think those meetings always took place when they were scheduled to. Back in the day, I used to have companies that it would take over a month before it showed up on the state website properly connected with the professional license. So that's going to be anybody like your lawyers, your doctors, your surveyors, your hair cutters. Anything that requires a professional license in Alaska usually is going to have the code that matches it, and it's going to require that you tie it directly to the company. It's better now. Now you get a drop-down menu and you can just put in the professional license number. It'll come up, you click OK, everything's good to go. Why it took 13, 14 years since I started practicing in 2011 to do that, I don't know. Oh yeah, the articles do have a $250 filing fee, and that is the document that basically says this corporation is now in existence. So after filing the articles, you're going to provide an initial report. So this is going to name the actual shareholders, and you're going to indicate who are the directors and who are the officers. Again, most times with a close corporation, the things I do, this is the same person. So you're going to have maybe 3 people. All 3 people are shareholders. One of them is a president, one of them is a secretary, one of them is a treasurer, and all 3 of them sit on the board of directors. So fairly common to do that. Then you have to get your business license in the name of the corporation. This has a $50 or $100 fee, depending on how you want to do it. I almost always do a 2-year license, mainly because of the fact that if you buy a license in November 1st, it's only good until December 31st. So this is because they send out their notices all at the same time, and they don't want to have a rolling mailing process to get people their notice that their business license is lapsing. And then the last step is to obtain an EIN from the IRS, which can luckily be done online. EIN is going to be a social security number for the business. All right, to actually finalize the corporation, we have to have the other documents done that are all internal documents. These are documents we're not going to file with the state, but they're documents you have to have because if anybody ever wants to really do business with you, they're going to ask to see some of this stuff. So the first one of those is the bylaws. Bylaws control the internal governance of the corporation. They can go so far as to spell out every little detail of how the company will operate. Most of the time, they're more basic. They do just touch on things like how shares can be exchanged, if shares have any restrictions, how the shareholders voting will occur, when the annual meetings will be held, where they'll be held, that kind of stuff. Most of the time I have just a template set of bylaws for a corporation, and I hand it over to the client and say, how does this look? And we just go through it and add and subtract as we need to. Again, in a close corporation, this doesn't come up a lot, and at any time, the board of directors, of course, could call a special meeting to adopt new bylaws if they so choose. The next are the stock certificates. So you do have to have actual physical stock certificates as far as I can tell. Somebody once asked if they really had to have these. I couldn't find a good answer in Alaska. So I think you do. I think you have to have these. Again, even though they're probably just kept with the corporate book, they're not usually handed out to the actual shareholders. And then you have to have the stock ledger. So again, even if you misplace the stock certificates, the stock ledger should tell you over time who owns what. And that's just a chart that tells you when somebody receives shares, how many they received, and if they sold them and who to. And then it would have that person's name. Okay, I received the shares here. That's all it does. But if you ever get audited, something like that, this is where you're going to find your actual shareholder information. Any questions on corporations that I can answer in the short term?
I did find out the East India Company was incorporated in 1600.
There you go. Good for me. I did minor in history. It was on the first slide. Everybody catch that? Good. All right, limited liability company is owned by its members. No board. There can be officers. Typically, though, it's just Greg, member, and that's it. Makes it really easy. Theoretically, an LLC can have a manager. So you may have a couple of members, but you might have a manager that doesn't have any ownership, but they have control over the company in terms of authority to deal with those third parties. We set up a few that way. Typically I'll do that when the members are really just financiers. So they've come in with the money and they want to maintain control over the company, but they're going to let the manager do the day-to-day stuff, pay a salary, something like that. But that's where it becomes a little bit different. Whereas a corporation can have what they call unissued stock, or sometimes treasury stock, which is stock that's bought back from a shareholder. LLCs have to be 100% owned at all times. So this is a plus and a minus in my mind. It's a plus in that it makes things very clear and easy. We don't have to see how many shares have been issued because sometimes that ends up not being 1,000, it ends up being 1,237. And then we have to track down and make sure we're representing all 1,237 shares, which can be a bit of a pain. We know an LLC is 100% owned at all times because that's how we're going to inform the state every time we make a change. So if it starts 50-50, but it goes 60-40, we have to make that change at the state level. So we send in a $25 filing, we know. The downside to that is it means that if you want to bring somebody into an already existing LLC, one or more of the members has to give up some of their member interest to do so. So if you're at 50-50 and you want to bring somebody in at 20%, it's got to come from somewhere. This is where you get a little additional flexibility in the LLC. So as I put up here, a member could own 70% of an LLC, but only be entitled to 20% of the profits, or some other set of numbers that offhand doesn't seem to make a lot of sense. But I've actually set up a few LLCs that way. I have at least one that I can think of where the financer basically wanted control of the company, but wanted the person who was interested in running the company to have some ownership, and to really make most of the money for the company. Financer just wanted to expect a regular payment coming in on a regular basis. So that's what they did. Financer was a 70% owner. The manager essentially was a 30% owner, but the 70% owner was only entitled to 20% of the profits. And that's how they set it up, because that worked for the business entity they had in mind. I've used that on a few companies, actually. So there's actually quite a few times where it becomes beneficial to be able to adjust ownership versus profit and loss. And the big one, LLCs do not share the same formalities that corporations do. There's no annual meeting requirement. Typically there's no resolution, so long as the operating agreement grants authority to the members to act on behalf of the company. Mine always do. That way you can sign things. We need a $100,000 loan. Great, lender, here's my signature. I'm Greg, member. Boom, we're done. They don't have to dig into that any further. A bank or somebody might ask to see the operating agreement, but vendors typically won't. Others don't really dig in that far. And it makes it just a whole lot easier. You're not wearing multiple hats. You're not doing something as an officer or a director or a shareholder. You're simply the member. Same thing for an LLC. Creating it comes with what we call articles of organization instead of articles of incorporation, because we're not incorporated, we're organized. $250 fee for this filing, just like under a corporation. Same thing for the initial report, although obviously significantly easier, because you're just putting the members and checking the box that says member, typically. Although I do believe that the initial report, even for an LLC, does allow you to name people as officers. Sometimes that's nice. You know, if you're an oil service company, oil guys like to see president next to a signature. So even though I'm Greg member, maybe also I'm Greg president sometimes, because it makes me feel, and that's fine. Same thing with a business license and an EIN from the IRS. And the EIN, I will usually do those for people. It's not particularly difficult since I've done it 100+ times. But they do ask some unusual questions on the business that you're in. So it just kind of depends. Sometimes, I mean, I'm trying to think, I've gotten an accountant's help on doing it, but I've always done it. So sometimes it's helpful to know. Sometimes it's helpful to have an accountant there to rely on when it comes to that kind of thing. LLCs are controlled by their operating agreement. So it's essentially the bylaws for the company. It's just called by a different name to keep things straight, I guess. Same thing though, sets out how the profits and losses are split and all that other information we went over for the corporations. Again, that document's not filed with the state. Most often when I do an LLC, it's a single member LLC. And so if down the road they're going to bring in another person to be a member of the LLC, we usually tell them, okay, at that time, come see me. We need to make changes to your operating agreement, because here is where we're going to put in things about what happens with the company when it dissolves. So we want to know who gets what. We want to know how it happens. We want to know if somebody can buy out another member over time. All of that's going to be in the operating agreement. So the moment you got more than one person involved, this is an important document, because if anything happens, we're going to come back to this document and say, well, here's what it says we're supposed to do. All right. So why bother to go through all this insanity? Spend all this money.
Yep.
Again, we've got to put that wall up. You just have to. I mean, it's so easy to lose everything when you get sued if you don't have this wall in place. So that's what we're doing here. We're creating a corporation or an LLC to put up that wall between your personal assets and your business assets. I'm sure somebody watching this will probably think to themselves, I ain't got any personal assets, who cares? Possibly true, but you're starting a business. Hopefully you will soon, right? I mean, that's the whole idea. You start a business to make money. So even if you don't have them to begin with, we want to protect them after the fact. So the question is, once we've put up our wall, can somebody breach it? Oh, yeah. Thank you, Samantha. So yes, they can. It is possible to do what they call piercing the corporate veil. This is an old doctrine that's been around ever since corporations have been around. And sometimes the corporation will do things they shouldn't be doing. And people who've been wronged by the company should be able to work their way toward the personal assets that the corporation is supposed to protect. Most often, this is in terms of a lender. So, yeah, got a lender to send you a bunch of money, and then you crash the company because you did something wrong. Well, that lender is going to be pissed, and they're going to want to come back and get their money, but you've already destroyed the company. So they're going to go to court and argue they should be able to pierce the corporate veil. And that's what's going to allow them to basically set aside the entity as a whole and go after your personal assets. This is not super common. It's not super common, but it does happen. Alaska claims to have two different tests. I've read them both multiple times. I'm not sure they're two different tests, and I'm not sure the state or the courts know which time they apply which test. Most states are very clear on this particular issue. I don't know why Alaska doesn't seem to have this one figured out. In essence, a plaintiff would have to show that there was some kind of misconduct on the part of the owner. Typically, what you'll see is some kind of fraud. You fraudulently induced me to lend you money. You claimed you had X amount of assets that you didn't, something like that. Alternatively, it'd be a personal injury type suit. I slipped and fell, you owe me $3 million. The reason I slipped and fell was because you're a terrible business owner and you don't follow any of the formalities. So I should be able to go after your personal assets because your business is only worth $300,000. So basically, these are the requirements to pierce the veil. There's got to be that initial requirement of fraud, wrong, dishonesty, or injustice. This comes right from a court case, so not the words I would have chosen, but that's all right. Most often, once you've got that fraud established, what they're going to look at is the lack of corporate formalities. Did you have your annual meetings? Did you vote for your directors for the board? Did the board do all the business? Or is this just a shadow? Is this company really just you running amok, claiming you're a company? That's what they're trying to look for. Undercapitalization sometimes can allow someone to pierce the veil. That one's a tough one because how do you know something's undercapitalized until you go into it, oftentimes? But if you have prior experience, maybe they can point to that and say, okay, you knew what your yearly revenue was going to be, and you started this company with way insignificant money. We should never have gotten to this point because you didn't plan ahead well enough. Domination and control by the shareholder, that's the sort of set aside entity. I'm claiming to be a corporation, but I'm not doing any of these things. And really, you know, I control everything. Most often you'll see this argument made when there's a lawsuit filed by a minority shareholder. So somebody who's an owner, but they don't own the majority of shares, and the majority owner has run amok. So somehow this minority shareholder has lost money over the years on this. They're claiming it's from mismanagement, fraud, wrong, dishonesty, or injustice, and they may be able to prove that the majority shareholder basically ran amok. They had all the power, they did whatever they wanted. The minority shareholder's input was never considered. That's where you may see that argument made. And the alter ego, instrumentality, that's sort of a combination of all those things. I'm claiming to be a business, but I'm not running it like a business. And then the most common reason we typically see is the commingling of assets. So you never want to pay your personal bills with your business account. You never want to pay your business bills with your personal account. Anytime you go into a business, I tell every client that walks in the door, you need 3 people to help you figure this out. You need your attorney, you need your accountant, and you need your insurance person. If you've got those 3 people lined up right, everything's going to be fine. But sometimes they don't have their accountant, and they'll start doing terrible things like, well, I didn't have any money in my personal account and I needed to pay the rent. And they'll pay it with a business check or out of a business credit card account. Well, you've put a check mark next to commingling of assets. And when you get, I don't know, half a dozen check marks there, it's going to be real easy for a court to pierce the veil. You're not really a company. You're going back and forth. Pretty easy to do. I don't think this happens very often in Alaska. I really don't. Again, maybe banks. Banks would probably pursue it beyond the veil. That's probably it. I can't imagine that there are that many cases out there. Again, I know judges don't know much about this stuff, so they're not seeing a lot of these cases. I wouldn't be surprised that it doesn't come up a lot because typically lenders have agreements that can use other state laws. So you're usually agreeing to a different state to govern the contract you're signing. Yeah, so that may be part of also why it doesn't come up a whole lot. All right, the Corporate Transparency Act. So this is a new federal requirement that was put into place as of January 1st this year. And when we started this, I mentioned that corporations and LLCs are essentially creatures of state law. Now we're looking at a federal law. Why are we looking at a federal law? Well, I don't know for sure. But essentially, the federal government decided that the best way to stop things like money laundering, to stop the Chinese from using shell companies, to prevent corruption generally, was to force every single corporation or LLC across the country to provide its beneficial ownership information to the federal government. This goes so far as to include who the beneficial owners are. It may not be the guy with 10% shareholder interest, but you know who it is? It's the guy with 90% shareholder interest. It's the officers. It's, God forbid, in-house counsel, actually. That's on that one. And then you've got to change it every time somebody changes either a name, an address, or a position. So it's created a lot of kerfuffle. It's created a lot of kerfuffle in the business world because it's probably overstepping federal bounds. Now, this is probably an unconstitutional requirement. Again, the states have always controlled this for the feds to step in and say, well, things are corrupt and we've got to fix it. This is the only way to do it. I'm not so sure that's going to hold out. So a challenge has already been brought in the Alabama District Court. And the court ruled that the Corporate Transparency Act exceeds the Constitution's limits on the legislative branch and lacks a sufficient nexus to any enumerated power to be a necessary or proper means of achieving Congress's policy goals. So that's where it stands right now, but that doesn't mean it's basically been overruled. It's currently been appealed to the whatever appeals court, whatever district Alabama is in, I can't remember now. And we'll see where it goes. So this is something that as attorneys, as accountants, we're keeping a very, very close eye on. As it stands right now, any company that was in existence before January 1st of this year has until the end of this year to register this. Any company created after January 1st only has 30 days, I believe. And it's a wholly different thing. You know, I understand what Congress is trying to do, but generally the feds don't get to step in and mess with something that's so heavy under state law like that. It can happen, but I don't know. So we'll see what happens there. I'm going to be following that very, very closely as we go.
Is that like a crash course that everyone files in December, or is it everyone just kind of holding back and waiting that it were in existence before 2024?
Yeah, I suspect so. I have filed a few companies I do a lot of work for, but other than that, I've not reached out to former clients or anything like that to say they need to do it. It's the numbers are almost unfathomable. I mean, how many corporations and LLCs are in existence in the United States? There's millions. I mean, and how many people work for each of those that would qualify as a beneficial owner? 10 times that amount? I mean, you're talking 100 million names. It's a whole thing. So yes, I suspect that people are going to wait. Hope that appeals court comes down with the decision within the next few months, and see where it goes from there. I would think that even if the appeals court were to side with the feds, that it would probably be appealed up to the Supreme Court and be overturned at that level. I don't know. I don't like to make those predictions, but this seems like such an egregious overreach by the feds that I think it probably won't last. All right, taxes. Now, I always try to stay in my lane as an attorney, so I'm only going to give you the broadest overview of taxes. I don't like taxes, not so much paying them, but I just don't like dealing with that kind of stuff. It's very complex, it's very specialized, and everybody's situation is unique. So when people come in and say, should I tax this as an S Corp? I don't know. I don't know how else you're making money. I don't know exactly what your business is doing. You need to talk to an accountant. So while I'm going to give a brief rundown, everybody talk to your accountants, please. C corporations are your Fortune 500 type companies. None of the corporations I set up are typically C corporations, very rare. C corporation has its own income, is basically its own person in terms of taxes. So Walmart makes 30 billion in a year, great, Walmart made 30 billion, okay. And then Walmart pays out dividends of some amount to all of its shareholders. Those shareholders earned the money they were given in those dividends. So the company's actually, the company is taxed once, the shareholders are taxed a second time. So this is where the whole double taxation idea comes from. That's why it's not very befitting for a small company. There's basically no reason you would do that. Instead, usually when we set up a corporation, we tax it as an S corporation. That essentially turns it into a pass-through entity. Oh, you own 10% of the shares, well, then you get your 10% of the profits. End of story. A lot simpler and just a lot cleaner for most people. A lot easier for people to understand what they're making and losing on a yearly basis too. But not all entities are able to be taxed as an S corp. So certain LLCs or corporations, particularly those that are passive in nature. So this is like a passive investment. Most commonly, this would be a real estate holding company. So I put my business property into its own LLC. That LLC cannot be taxed as an S corp. Passive income does not qualify for what the IRS likes to see there. If you're going to tax it as an S corp, you need to be personally putting in the work for the business. So passive investments do not qualify for S corp status. If they don't qualify for S corp status, you can always just be taxed as a sole proprietor. That's another box you can check. Again, essentially it's just you. I'm just Greg, the member, and taxes pass through to me, and that's it. End of story. Which is fine for a lot of people, but again, it might depend on how you're making other money. What other investments do you have? What other jobs are you working? That kind of thing. And here Sam helped us out with a little, I guess these are government fat cats. All right. All right, that's it. So that's the bare basic bones presentation on corporate entities. Now, who wants to take the conversation higher with some questions?
I have one going back a couple slides.
Yeah.
And it was when you were talking about specifically before taxes about things that will pierce the wall.
Yeah.
And that one. So like example, so you talked about commingling of assets.
Mhm.
And let me have you clarify that a little bit, or maybe just go a little bit more into that. So let's say in the corporation itself, you said, so owner doesn't use company money or company check to write money towards personal whatever, right?
Sure.
But if owner of company writes themselves a check,
Mhm.
that now becomes their money, and how
Right.
they spend their money is how they spend their money.
Correct. So when
But
you're
as long
taking,
as the check doesn't state the company's name, the money that comes out, it really doesn't matter how that money is spent. And arguably, I guess, if it were to go to court under
Mhm.
this proceeding, they wouldn't necessarily go back and say, well, clearly you wrote these checks to yourself, and then
right.
you went and spent the money however it was. Or is there kind of a loophole in that?
So that's generally correct. So the key there is that whatever you're doing, you need to be following generally accepted accounting principles. And part of that is that if you're going to give yourself money from the company, it needs to be listed as a draw on your books. That draw, that's fine. But if it's on there
It went to that individual.
because it went to that person, that's
Right.
fine. Now that person can do whatever they want with the money to pay their bills. But yeah, you really, that really, when it comes to commingling of assets, the easiest way to get caught for that is your QuickBooks usually, because it's going to say something like, oh, this check was written to HEA. It's like, oh, well, that was to my HEA account. Well, now we know.
Got
Yeah, so with commingling, it's always, it's one of those things where if you do it a handful of times, maybe not that big a deal. Oh, I screwed up, I grabbed the wrong checkbook. Okay, that's fine. But the more checks you add to commingling of assets as you go, the more likely it is that they're going to look at that and be like, yeah, we're going to let them pierce the veil on this one.
And arguably, I guess in a sense, then it's stating that if the company owns that asset, payments from the company validated, that's good. The company does not own that asset and it's writing a check to pay for said individual.
Yeah, that's basically what it comes down to. And that's where, you also run into issues like that, where you run into people that try to put their cars in their business. It's like, well, it's not really a business vehicle. It's your car, you're driving it to work, but that doesn't count. And so things like that, when you're doing that sort of like skirting the tax law kind of stuff, that can hit you under commingling of assets, depending on how it's done. So yeah, that one's always dangerous. That's the one thing I tell every client when they leave. Do not pay your personal bills out of your business accounts. Do not pay your business bills out of your personal accounts. If you need to do one or the other, take that personal check, write it to the bank, put it on your QuickBooks as a loan, and resolve it down the road somewhere. That's fine, but
Or just pay yourself.
or just pay yourself if the money's there.
Right.
Yeah.
In a sense,
Mhm.
there's a cleaner way, in a sense, to make sure that it keeps it.
Yep, and
The
typically,
tax man's going to take care of that at the end of the year, regardless.
Exactly.
The QuickBooks is going to say this individual got all this money.
right.
Now this is how they're being taxed.
And typically, when somebody asks me, well, how do I do that? I send them to the accountant. Talk to your accountant.
Right.
They'll tell you how to do it properly. So yeah, I don't I don't tell people how to move the money around. There's a joke at my office, like people will come in and try to write me a check. And like, I don't let the attorneys handle the money. It's not how this works. Any other questions? I don't know who this guy is, but I like it. How long did that take me?
An hour.
An hour.
Great.
You're the first one to actually do the lecture series in a full hour.
Okay, awesome. Great. All right, well, thank you, everybody. Appreciate it.
Yay, good job.
We'll all be receiving bills shortly. Be sent to you in the mail.
Really took an hour? Jesus. I wasn't sure
like
typing
that.
up. It's really hard to know, like,
Mhm.
because I can talk. I'm an attorney. I'll talk. Give me a mic. It's fine.
You did great. Good information.